morning and welcome to Melanie's Minutes, where we discuss a workers' compensation issue by the beach, because workers' compensation can sometimes be a beach. Today we are going to discuss the issue of the claimant's requirement to produce up-to-date medical evidence. If a claimant has not yet been classified with a permanent partial disability, then there is no presumption of ongoing disability. And therefore, if the medical report is in the file, it is only good for 90 days. If after that 90-day period there's no up-to-date medical, then we recommend filing an RFA to request suspension of those awards. That's why it's really important to diary the CCPs that are made on a file, because sometimes we can, lose track of them, and all of a sudden it's 6 months down the road, and you've been paying total disability for 6 months, and the claimant hasn't produced anything in the last 9 months. So therefore, just remember that monitoring the claimant's folder, make sure that the disability is actually consistent with the medical and the CCP. If you have a CCP at 100 or a total disability, and then the doctor reduces it to 75, we're going to want to get those reduced. It's also very important that there's only a few cases where you can reduce or suspend a CCP alone. Typically, we have to file an RFA. We have to make the parties aware that we are that we seek to suspend awards and go through the process of a hearing and indicate why. Additionally, if we get an IME and there's a lower degree of disability, we're going to want to make sure that we file that RFA right away, and therefore we can get it for a hearing to get those awards reduced also. So just always make sure that you are monitoring the file and that you make sure that there is up-to-date medical being produced. Another situation is the claimant will produce medical evidence, but there's no opinion on degree of disability. And also another something to do with the expanded provider law is that if there is ongoing disability and we are on a CCP, and then there's a change, let's say it's from a 75% to a total, and that initial report is produced by a PA and there's no medical doctor's signature, that's not a basis for the awards to be increased under expanded provider law. So there are definitely some nuances that need to be addressed, and it's a factual determination, but just generally it's really important to monitor the medical evidence, especially for a claimant who has not been classified. And eventually, even if we don't get an IME, you may want to develop a record on that. If a claimant is at a total disability for an extended and unreasonable time, and they're not coming down from that, and there's no indication that they will, that we don't need an IME to cross-examine that doctor on that issue. So if you have any questions, if you have any issues with payments or any issues with a claimant who's not producing up-to-date medical, we'd be more than happy to assist you, and we will see you next time. Thank you.